Internal documents obtained exclusively by the Washington Post reveal a previously unknown February 14, 2024, emergency session in room 419 of the Dirksen Senate Office building that fractured Washington's power structure over the Epstein case like nothing since the Church Committee. Convened at 10:07 p.m., under the official title Classified Briefing on Ongoing National Security Implications of SDNY Docket 15 CV 07433, the meeting actually became a 3-hour shouting match between the intelligence community, Senate leadership, the federal judiciary, and victims' counsel that left permanent scars across party lines and branches of government. Attendance was restricted to 28 people. The full membership of the Senate Select Committee on Intelligence, Chief Justice John Roberts, Circuit Judges Deborah Ann Livingston and Jose Cabranes from the Second Circuit, Attorney General Merrick Garland, FBI Director Christopher Wray, CIA Director William Burns, NSA Director Timothy Hoff, and for the first time ever in a classified congressional setting, Virginia Giuffre and 2 other named Epstein victims represented by Sigrid Macaulay. Sources present described the temperature in the room as hostile from the moment the doors were sealed. The meeting began with a 22-minute CIA presentation claiming that continued Epstein unsealing would compromise 47 human sources inside Russian oligarch networks and 19 assets inside Chinese financial intelligence units who had been developed using information originally extracted from Epstein's Palm Beach and New York servers in 2019. Director Burns displayed redacted still frames allegedly showing a current European Prime Minister and a former NATO Secretary General on Little St. James, and warned that Moscow had already prepared deepfake packages timed for release during upcoming elections. He requested immediate suspension of all further docket releases and transfer of the entire physical archive to Fort Meade, under NSA custody. Chief Justice Roberts responded with a 9-minute statement that has since been described as the angriest any senator present had ever heard from a sitting Chief Justice. He accused the intelligence community of weaponizing classification to shield the powerful from accountability, and reminded the room that the Supreme Court itself had unanimously denied certiorari in the Maxwell appeal precisely to let the judicial process run its course. Roberts told Burns directly that if the executive branch attempted to remove evidence from Article 3 custody, the judiciary would regard it as a constitutional crisis of the first order. The breaking point came at 11:38 p.m., when Virginia Giuffre was granted the floor. Speaking without notes for 12 uninterrupted minutes, she read the names of 8 still living individuals who appear in the sealed portions of her own deposition, and stated that every delay since 2015 had resulted in additional victims taking their own lives. When a CIA deputy tried to interrupt on grounds of classification, Senate Intelligence Vice Chairman Marco Rubio slammed his hand on the table and said, "She has lost more to this case than your entire agency combined. You will let her finish." The room fell completely silent. Attorney General Garland then attempted a compromise. The Justice Department would agree to accelerated unsealing of all non-intelligence-related material if the victims and the court accepted permanent redaction of any name currently holding an active security clearance or appearing in ongoing foreign operations. Sigrid Macaulay immediately rejected the offer, producing a list of 41 individuals already publicly identified in flight logs, and asking how many more decades the government intended to grant them immunity. Senator Mark Warner attempted to find middle ground by floating a hybrid panel of cleared victim attorneys who could view classified portions and advise the court, but NSA Director Hoff shot it down, saying even limited disclosure to non-agency personnel would violate compartment rules in place since 1953. At 12:51 a.m., the meeting splintered into smaller side conversations that sources describe as near physical. Senators Ron Wyden and Tom Cotton were seen arguing face-to-face over whether the intelligence community had deliberately slow-walked the original Epstein investigation to protect sources. Judges Livingston and Cabranes told Garland privately that the Second Circuit would deny any emergency stay unless the government produced specific source names and recruitment dates in open court, something the executive branch had already ruled out. Meanwhile, Giuffre was overheard telling Roberts that if the judiciary could not protect victims from the intelligence community, the victims would begin releasing their own archives to overseas press, with no redactions whatsoever. The session ended at 1:14 a.m. with no agreement and 2 explicit threats that have chilled Washington ever since. First, Director Burns informed the committee that if the court proceeded with the next scheduled unsealing on March 1st, the intelligence community would be forced to invoke the 1982 Intelligence Identities Protection Act and seek criminal contempt charges against any judge or clerk who transmitted classified material to the public docket. Second, Virginia Giuffre's legal team announced they had already transmitted encrypted copies of the complete sealed archive to 5 independent journalistic organizations in Europe and Australia, with instructions to publish everything on March 2nd if the SDNY docket remained frozen. Chairman Mark Warner declared an immediate recess and cleared the room, except for the Gang of 8 leadership. What was said in the final 40-minute executive session remains classified at the TSSCI level, but senators emerging afterward refused all questions, and several appeared visibly shaken. Within 48 hours, the Justice Department withdrew its emergency stay motion. Without explanation, Judge Preska quietly advanced the next unsealing batch by 10 days, and the intelligence community began an internal review of every Epstein-related intelligence file that one participant described as the mother of all damage assessments. Tonight, the physical evidence remains in the SDNY vault under 24-hour judicial guard, while a new inter-branch working group meets daily in complete secrecy. Multiple sources tell the Washington Post that the February 14th confrontation has created fault lines that will not heal for years. The intelligence committees no longer automatically accept agency classification claims. Several federal judges have begun demanding raw intelligence before granting stays in any sensitive case, and the victims have made clear they will never again trust any government process that operates behind closed doors. What began as a dead financier's civil lawsuit has become the first genuine constitutional confrontation between transparency and secrecy in the post-9/11 era, and no one in that room believes the crisis is anywhere close to resolution.